everything. So it's just like I've gotten a new computer. So all of my settings, everything that was saved, I just tried to click on the YouTube, which is normally saved, but I had to enter the. So it's just like I've gotten a new. Hold on. So all of my settings, okay. So I apologize for that delay. All right, so Mr. Smith and Ms. Pitman Smith, you have taken advantage of the opportunity to hire Mr. Fortis as your lawyer. Mr. Fortis, for your benefit, I have reviewed the warrants and the criminal histories for both of your clients. Mr. Smith has, I think, one arrest, and Ms. Pitman Smith has maybe three arrests, prior arrests before this. So they both have relatively light criminal histories. I'm going to point you in the direction of what I'm thinking of, but I'm going to give you the opportunity to say whatever you want to say as it relates to your clients. It seems like they're both eligible for bond. My biggest concern is the amount of narcotics that was in the residence. So I'm inclined to grant them bond. The number is going to be, I think, the biggest issue, but I will listen to you as to whatever you want to tell me about your clients and these charges.
You ready, Judge?
Yes, sir.
Okay. So, Judge, I'll start with Miss Pitman Smith. She is 34 years of age. She has been married to Mr. Smith. They've been married for approximately 1 year. She's been in Georgia since 2005. She works at Walmart. She's a manager at the Walmart on Old National. She's been there employed there since 2015. They have no biological children together. She's not on probation. I don't know about the three arrests. I'm not sure if there are any convictions. I do believe, like the court, that I do believe that she meets the IALA requirements for bond. The reason why, Judge, while you're looking at the number of narcotics, I think the majority of that has to do with some vape cartridges, and I think that what they did is, and I'm not 100% sure, but my suspicion is that they've taken the THC cartridges or vape cartridges, whatever you want to call them, and then they've charged those individually. While there may be a couple of other charges, I think it's all marijuana related. So while on paper it doesn't look very good, it looks like it, from my vantage point of what I know, it looks like a little bit of piling on. But I believe it's just marijuana related. So that would be my argument for Ms. Pitman Smith. And I'm not sure what number the court is thinking about, but what I was thinking of was a $5,000 bond on all charges.
Okay. I wasn't thinking that number. So I'll tell you generally how I think. If you have what's listed in the affidavit is 35 THC pens, 15 bags of green leafy substance, 14 bags of THC edibles, and it says altogether about 5.74 ounces. Now, I understand what you're saying about the parceling it out, and I don't necessarily disagree with that. But with what I see, it looks like this is sort of the allegation can be made that this is a business.
Let me say one other thing, Judge, and I certainly don't mean to interrupt you, but this is a crucial point to this, but I really don't like to get into the facts at this point. But Mr. and Miss Smith take care of Miss Smith's stepson, and how all this came to be is that Mr. Ruiz, who is the stepson of Mrs. Pitman Smith, they were trying to help him. He has some, I would say, some mental
schizophrenia, right? And he had been released from Southern Regional, and he's correct, the one that made the call. And I understand that. And
a lot of the marijuana that you're referring to was in his room, but that's an argument for a different day. And my understanding is, and I've spoken to her parents about this, that he was subsequently arrested for smoking marijuana at a Walmart where they got him the job, along with terroristic threats. My understanding is that he may have already made bond on those charges, but as the facts unfurl a little bit, I have a feeling that that's what's going to come out. I know that's not an argument for here, but it's just my argument for the court to consider something significantly less than maybe what the court is thinking with respect to bond.
And I'm happy to have the conversation. So the allegation, as I read, was that as it started, the allegation is that Mr. Smith had a garbage bag that contained marijuana, 3 ounces maybe of marijuana, and he was taking it out and placing it in garbage. Now, if I take your argument and carry it out, if Mr. Ruiz is the person that made the phone call, the drugs were in his room, it would seem to me that a reasonably prudent person would say, hey, all of this stuff belongs to him. It doesn't belong to us. This is his room. And that may have not led to an arrest. I don't know. I can't, as this discussion only fits as to what is a reasonable bond. Okay.
Understood.
So it's not about whether they are convicted or whatever, but all right. So is there anything else, Mr. Fortes?
I mean, only in consideration that, obviously they were to be working quite a bit over the holidays, and they've missed that. And so they've had to inform their employer to take a leave while they can try and get out without losing their jobs and their managerial positions. Other than that, nothing else.
Okay. So I have to set a bond for each offense or they're not going to be able to get out.
Understood, Your Honor. Thank you.
I'm just trying to be consistent for each as to the charge. That's what's taking me some time. Okay, so for Miss Pitman Smith, first warrant charges her with possession of firearm during the commission of a crime. I've set a $4,000 bond for that. The second charge or warrant is manufacture, violation of Georgia Controlled Substance Act, manufacture, sale, distribution, or delivery of a controlled substance. I've set a $10,000 bond for that. Possession of drug-related objects, bond's going to be set at $1,500. Possession of Schedule I controlled substance, bond's going to be set at $3,000. Second count, possession of Schedule I controlled substance, bond is also going to be set at $3,000. The VGCSA manufacture, sale, distribution, deliver controlled substance, bond is going to be set at $10,000. Possession or possessing the substance to manufacture a controlled substance, bond is set at $2,000. And for the second count, bond is also going to be set at $2,000. So by my math, that's a total bond of
Jesus Christ. It's high.
Did you say that that's high?
Well, I was thinking about, I was adding it up. I apologize. I thought it was a little high, but higher than what I expected, but that's okay.
So
But
Mr. Fortis.
Yeah.
Okay, sir. First, you're appearing without a tie on, and I've tried to look that over. If you're going to be making comments about my decisions, then I may need to start making comments about you. Okay, sir.
I understand, Your Honor. I didn't mean any disrespect. It was just my opinion, but I certainly respect the court's decision. I'm not disagreeing with the court. I was just kind of adding it up as I was going in my head, but I understand the court's position. I apologize.
Some may view it as a low-level sign of disrespect for the court.
I understand, Your Honor, but I didn't mean that, and I want you to understand that. I apologize. I'm grateful that Your Honor is inclined to set a bond.
And I reset the case so that you could be present.
And I understand that, Judge, and I didn't get retained until, the last minute, and that was not why I was there. So I was not present for any other reason. So I apologize, Your Honor.
Okay, so it looks like my total bond is $31,500 for Miss Pitman Smith. And you can check the math, but it's on the bond order.
That's correct, Your Honor.
And for Mr. Adonis Smith, the total bond by my math is $37,500.
And Judge, and the increase on that would be which warrant on that?
Well, he has more charges.
Understood.
So he has the tampering with evidence.
Right.
And I set the bond at $2,000 for that. And I'm sorry, I didn't announce the bonds. For manufacture, sale, distribution of controlled substance, bond is set at $10,000. Possession of Schedule I controlled substance, bond is set at $3,000. Manufacture, sale, distribution, deliver a controlled substance, bond is set at $10,000. Possession of Schedule I controlled substance, bond is set at $3,000. The manufacture, sale, distribution, and of controlled substance, 2 counts, bond is set at $3,000 for each of those counts. Possession of a weapon during the commission of a crime, bond is set at $4,000. Use or possession of drug-related objects, bond is set at $1,500. Tampering with evidence, bond is set at $2,000.
Thank you, Judge, and I appreciate that. And I would, just for the record, I would adopt the same arguments, other than the background information for Mr. Smith as well, for time's sakes.
I understand. I think Ms. Pitman Smith had prior trafficking of cocaine arrest. The preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon their bonding out, and they will receive a new court date in the mail.
I appreciate that, Judge. And again, I was just kind of adding it up in my head, but there was certainly no intent of disrespect to the court. I apologize for that.
Yes, sir.
And may I ask
Thank you.
the court one other question, please?
Yes,
There was
sir.
another matter. I was waiting on my client to arrive in the Clayton County Detention Center, and my client's family called and said that he was there. I just want to make sure he's not on this morning. His name is
Okay.
Bernard Arnold.
Mr. Arnold is not on the calendar today. No, he's not on the calendar today. If he's in, depending on when he came in, he may be on the calendar for tomorrow. That'll be Judge Stephen Knights will be presiding over the first appearance calendar tomorrow.
Well, Judge, thank you very much, and I appreciate it. Thank you.
Okay, these bond orders will be entered later today. You're free to go, sir. Ms. Pitman Smith and Mr. Smith, you're both free to go back.
Thank you.
Let's bring up Mr. Bush for Mr. Florio.
Good morning, Your Honor.
Good morning.
I apologize for being 2 minutes late, Judge, and I'm not saying this to be contrary, but it was because I did not have a tie or a coat on. And that's why I logged in at 11:02, Your Honor. I promise you, I was in a mad dash to make sure that I was respectful of the court.
I do appreciate that, and I try not to be a person that takes that as sort of a hard and fast rule, because things happen. But I think at some point, the comment about, oh God, that's high is just a little too much for me to take.
It was certainly not professional or appropriate for a courtroom setting.
No, Mr. Bush, good morning, sir. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm going to be presiding over this hearing. You've taken advantage of the opportunity to hire a lawyer, Mr. Florio. So normally I would speak to you, but I'm going to speak to Mr. Florio directly. But I want to caution you that this is not a private setting, so don't say anything you wouldn't want the whole world to know. Okay, sir? So, Mr. Florio, your client is charged with 1 count of possession of firearm by a convicted felon. I have not weighed in as to bond on this. I would like to hear from you as it relates to your client. I believe he has a prior conviction of armed robbery and aggravated assault.
He does, Your Honor. Mr. Bush has one prior conviction in life, one prior felony conviction, in life. He was 16 years old and arrested and charged as a juvenile with that armed robbery here in Clayton County. Obviously, even though he was a juvenile at the time, the case was transferred to Superior Court and he was prosecuted before the Honorable Judge Benefield. At 16 years old, he did receive a 12-year prison sentence, obviously of which he did every single day. He was released 3 years ago, and since then has largely worked to try to turn his life around. He does have another arrest for which he received misdemeanor probation from the Honorable Judge Mack, but he's not on probation at this time. It was a misdemeanor sentence from the Honorable Judge Mack, 18-month misdemeanor sentence, I believe. As I understand it, and obviously I'm kind of working secondhand, I've had contact with many of his family members. His brother reached out to me. I've known Mr. Bush and his brother and other family members now for the last 3 years. His brother reached out to me last night, as did other family members, in concern to Mr. Bush's arrest. I believe that he was arrested in an auto. There was a traffic stop conducted. I believe it may have been based off of a window tint violation. I believe Mr. Bush was the front seat passenger in that car. From what I understand, there were 5 individuals in the automobile. There were 2 firearms located. What I've been told is that there was a female in the back of the car who claimed ownership of one of the guns that may have been in a purse or something of that nature. I believe there was a second firearm located in the back seat of the car, and everyone was charged. There may be an allegation that Mr. Bush took ownership of that gun. His brother believes that there may have been that allegation. If that's true, I've known Jarvis Bush now for 3 years. Jarvis Bush wouldn't agree that today was Monday, let alone that there was a gun in the car that was his. I mean, he did 12 years to the door in an armed robbery case. There's no way I believe that this young man would have ever said that any gun located in any car was his. He was not the driver of the car. He was not the owner of the car, and the gun was not found on his person. Obviously, and I know the court knows this law better than I do, certainly. But obviously, the owner of the car is presumed to possess what's in it, as is the driver of the car. And Mr. Bush was neither the owner nor the driver. It was just an automobile. It was a firearm, as I understand, located in the back seat of the car. There would have been 2 young men in the front seat, Mr. Bush being one and the driver being the other, and 3 young ladies in the back seat. Certainly, we'll be prepared to address these charges before the Honorable Judge Mack when this case goes to Superior Court. We would ask that bond be set in this matter. He does live in Union City. He has 2 twin boys. They're 2 years old. They turned 3 in May. He lives with his children. His children and the children's mother all live together in Union City. He's actively employed by a moving company here on the south side of Atlanta. I would ask that bond be set in the amount of $5,000. I think it takes into consideration, I understand he is a convicted felon, and I understand he certainly has been convicted of a serious charge. And I certainly don't mean to minimize that, but he was 16 when he did it, and he did it. He pled guilty and was sentenced. He was 16 when he did it. And oftentimes the decisions we make at 16 are a lot different than the decisions we would have made when we were older. He certainly paid the price for that, having spent 12 years, almost his entire 20s in the state prison system. And I've talked to him a lot about that, and it certainly changed him growing up in the state prison system. But he's done a lot to try to rehabilitate his life and turn his life around, and really dedicated himself to family. So I would ask for a $5,000 bond. I think that's a bond that his family has a realistic shot at making, Your Honor.
And I will, for the record, take into account the circumstances under which the firearm was located, as you have outlined in your argument. I don't believe that $5,000 is unreasonable. I will let you know, Mr. Florio, and you don't have to comment on this, but in the warrantless arrest affidavit, there was a notation that your client was allegedly convicted of possession of methamphetamine on January 14th, 2019, but that does not show up in his criminal history. So I'm not taking that into account, but that's something that you may want to look into.
And Your Honor, just for the record, I'll look into that, but I don't believe that is accurate. He was arrested, but I believe that the Honorable Judge Mack sentenced him to 18 months of misdemeanor probation. It was out of the Superior Court of Clayton County.
Okay.
And so I don't believe that's accurate. I believe he was convicted instead of something else. I'll double check that. I did not represent him. He was represented by their counsel. So
Okay.
If I'm wrong, it certainly is not an intentional misrepresentation to the court, but I don't believe that's accurate.
I understand. Okay. Well, I'm going to set bond at $5,000. Is there anything else, Mr. Florio?
No, sir. Thank you very much for that consideration, Your Honor.
You're welcome. You are free to go, and Mr. Bush, you're free to go back.
Thank you very much, Your Honor. Your Honor,
Have a
that
good day.
concludes my business before the court may be excused.
Yes, sir. Have a good day.
Thank you, sir. You as well.
Okay, let's get started with the reading of the script. Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. Now, I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, the person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, would everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God?
I do.
Okay, let's begin on the ladies' side. Looks like the first person I have is Erica Body.
Yes, Your Honor.
Ma'am, you're charged with one count of violation of Georgia Controlled Substance Act. Bond is going to be set at $2,000. One count of an open container violation. Bond is going to be set at $500. And one count of misdemeanor possession of marijuana. Bond is going to be set at $1,500. Do you believe you can post this $4,000 bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Ms. Bond?
Yes, sir. Candace Bond.
Ma'am, you're charged with one count of obstructing an officer. Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. You want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss, for the record, Heather Michelle Congo, I received a notice that she has a COVID diagnosis and she's in protocol. I have dismissed the obstructing of an officer charge, and I've set a bond of $1,500 on the giving a false name, address, or date of birth charge. I'm going to send those documents over at the end of the day, so she'll be allowed to post a bond. Are you Miss, is it Houston or Houston?
Houston.
Miss Houston, ma'am, you're charged with possession of a firearm by a convicted felon in violation of Georgia Controlled Substance Act. I have an indication that you were that you were convicted of aggravated assault on November 4th of this year. So that would prohibit you from getting a bond at this proceeding.
No, I don't have no probation.
Were you convicted?
No.
Okay. All right, ma'am. Well, as of now, I'm not gonna set a bond. I'm gonna, ma'am, please let me finish.
Okay, yes, sir.
As of now, I'm not gonna set a bond. I'm going to look and make certain that you are not on probation or parole. If I determine that you are not on probation or parole, I will set a bond of $5,000 on the possession of firearm by a convicted felon and of $3,000 on the violation of Georgia Controlled Substance Act. Are we clear on that?
Yes, sir. When I will find out.
I just told you, ma'am. Ma'am, I can reset your case to tomorrow, or you can allow me to look at this and make a determination. And if what you're saying to me is true, I'm going to set a total bond of $8,000.
Okay.
Okay.
Yes,
The
sir.
way that you will know that, I'm telling you this information now so that if you're going to use a bonding company, you can start the process of contacting the bonding company, telling them your charges, telling them the bond amount the judge said he was going to set if you are not on probation or parole. They have a computer system where they will be able to know if it's been set. And they will tell you it's been set. Or they will tell you, no, it has not been set. The only other thing I can do is reset your case till tomorrow. You
Okay.
tell me which one you want me to do.
Set my bond.
Okay. So it'll be $5,000 on the possession of firearm by a convicted felon, $3,000 on the violation of Georgia Controlled Substance Act. You're going to have a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. And again, I just have to double check this because your information came over late and I did not have access to your GCIC, which is your criminal information. So I'm going to look at it. Now, it's pretty specific saying you were convicted out of Atlanta on November 4th of 2021 for aggravated assault. So once I get your criminal history, if it says that, you're not going to get a bond. Okay?
Yes, sir.
Would you like me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, do you have any other questions about what's going to happen next?
No, sir.
Okay, you're free to go back, ma'am. Miss Ramsey?
Yes. Good morning.
Good morning, ma'am. You're charged with one count of simple assault. I've set the bond at $2,000. Do you believe you can post that bond?
Can't pay it till Wednesday when I get paid.
Okay.
I get paid on Wednesday.
Okay. There's going to be a stay away provision on this bond to stay away from a Charisma Roberts. Do you understand that?
Yes.
What do you not understand?
No, I said I do understand. Yes.
Oh, okay. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. And looks like you refused the appointment of counsel. So you're going to hire your own lawyer?
Yes.
Okay. All right, ma'am, you're free to go back.
Okay.
Miss Yates? Ma'am, you're charged with one count of aggravated assault. Bond is going to be set at $10,000 for that offense. One count of family violence battery. Bond is going to be set at $5,000. One count of leaving the scene of an accident. Bond is going to be set at $1,500. One count of criminal damage to property in the second degree, and that's a felony. Bond is going to be set at $5,000. And one count of possession of a weapon during the commission of a crime. Bond is going to be set at $3,000. So you're going to have a total bond set at $24,500. Do you believe you can post that bond?
Not today.
Okay. There's going to be a stay away provision on the bond, stay away from a Kenyatta Glover. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes. Yes,
Okay,
sir.
you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Your Honor, that's it for the female side.
Thank you for your assistance. Have a good day.
Yes, Your Honor. I'll get word to Ms. Congo as well.
Okay, thank you.
Yes, Your Honor.
All right, let's switch over to the male side.
Anderson.
Mr. Henderson, sir, you're charged with one count of possession of firearm by a convicted felon. I'm going to set a bond at $5,000. You believe you can post that? Oh, well, I'm sorry. It's going to be $5,000 for possession of firearm by a convicted felon and $500 for the improper lane change. Do you believe you can post this bond of $5,500?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I see you plan on hiring your own lawyer.
Yes, sir.
Okay. Do you have any questions for me?
No, sir.
Okay, Mr. Henderson, you're free to go back, sir.
All right.
There's a whole.
Okay. Mr. Holt. Mr. Holt, sir, you're charged with one count of criminal damage to property in the second degree. That's a felony offense. Bond is going to be set at $5,000. And one count of simple battery, that's misdemeanor. Bond is going to be set at $3,000 for a total bond of $8,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Demeter Hall. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Holt. Mr. Jelks?
Jones.
Mr. Jelks, sir, you're charged with one count of DUI alcohol. Bond is going to be set at $5,000. One count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And open container violation bond is set at $500. All of these are misdemeanors. It's going to be a total bond of $7,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I don't.
Okay. All right. You're free to go back, sir. Maria, I just saw your text.
Yeah, I was actually, I see that, February the, 7th is on a Monday, which is when we do felonies. And
Right.
then that Tuesday is for the misdemeanor, which is February the 8th.
Right. Which one do you think I got wrong?
I think, hold on just a second. It was a misdemeanor, that you did, and it was placed on the, 7th.
Okay. Find that person and just put it in the text.
Okay.
All right. Thank you.
All right.
Okay.
Langford,
I'm sorry. Say that again.
John Langford,
Oh, Langford. Oh,
Yes, sir.
what happened to Mr. Johnson?
oh, I'm sorry, Ms. Johnson. I'm sorry about that, y'all, he's coming up.
No problem. Mr. Johnson, sir, you're charged with 3 counts of aggravated assault. Bond is going to be set at $30,000. And 1 count of assault on an unborn child. Bond is going to be set at $5,000. So that's going to be a total bond of $35,000. Do you believe you can post that bond?
I thought it was, my, paper says one count of aggravated assault and another count, it was supposed to be 2 on the paper I received.
It's 3. Audrey Stovall, Dana Collins, and Devon Blango are the victims.
I got you.
Okay. So the bond's going to be set at $35,000 total. There's going to be a preliminary hearing date set for February 7th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay, you're free to go back. Mr. Langford,
Yes, sir.
sir, you're charged with 1 count of improper passing. Bond is going to be set at $5,000. 1 count of driving under the influence of alcohol. Bond is going to be set at $5,000. An open container violation. Bond is going to be set at $500. And possession of marijuana edibles, which is a felony offense. Bond is going to be set at $3,000. So that's going to be a total bond of $9,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
This time, thank you.
Okay, you're free to go back.
Mrs. Levy,
Sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond to stay away from a Linda Levy. Do you understand that? Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Ms. Price,
Mr. Price, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000 for that offense. 1 count of criminal trespass. Bond is going to be set at $3,000. And 1 count of cruelty to children. and the third degree bond is also going to be set at $3,000. These are all misdemeanor offenses. The total bond is going to be set at $11,000. Do you believe you can post that bond? There's going to be a stay away provision on the bond, a stay away from a Terry Pearson. Do you understand that? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, no.
Okay. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
Ms. Todd. I don't want to pay attention.
Mr. Todd, good morning, sir. You're charged one count of obstructing an officer and one count of public drunkenness. Bond is going to be set at $2,000 on obstructing of an officer and $1,000 for the public drunkenness. That's a total bond of $3,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I apologize for that. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Oh, yes, sir. Just
You go
wondering, do you think I could do a signature bond? No?
No, sir.
Okay.
Okay, you're free to go back.
Thank you.
Is it Mr. Namachi?
Yes, sir. Good morning, Your Honor.
Good morning. Sir, you are here on a slightly different situation. The same rights and privileges as I discussed earlier applies to you. However, you're here on what's called a fugitive from justice warrant. And what that simply means is that there's a warrant for your arrest out of the state of California. The Orange County Sheriff's Department has a felony grand theft warrant, and they've indicated that they will extradite you. And what that means is that Clayton County has no interest in this charge. We're simply holding you on behalf of Orange County. If you believe that you're not the person named in the warrant, and if you believe that, or if you believe that these charges are not valid, you can challenge this warrant. And what that means is that sometime between now and the next 90 days, there will be a hearing held here to determine if you are the person named in the warrant and or if the warrant is in fact for a valid charge. We have no interest in your guilt or innocence. It's not going to be a trial to determine whether you're guilty or innocent. It's just a matter to determine whether the right person is named or listed. If you believe that that is your true and correct legal name, and you believe that this warrant does exist, you can waive the right to that hearing. And if you waive the right to that hearing sometime within the next 30 days, Orange County Sheriff's Department, they will come and get you and take you back to California. If they determine, well, at some point within that 30-day period, if they determine they're not going to come and get you, they'll notify the fugitive squad here, and they will then release you. However, doesn't make the warrant go away. So you're going to have to deal with this at some point. Do you have a lawyer representing you out in California?
Yes, I have a lawyer, but I haven't been opportunity to communicate with him really from here because all this happened so quickly yesterday. At the airport, I was traveling to Nigeria, and there was stops at the gates when I was trying to check in.
At the airport? So you got arrested at the airport?
Yes.
Okay, so
because I was told by the officer who arrested me that there's a bond of a $100,000 bond to be charged. Okay, if I can communicate with California, they will make a decision. But I don't know because I haven't seen all the paperwork myself.
So you should rely upon your counsel out in California. I had a similar situation that occurred, I believe, on the 23rd, where a person was traveling and they went to the airport and the warrant showed up and the person was arrested. And it was out of California. There was a bond set on the warrant. And so, hold on. The way that this works is like we can only talk at one time. And I promise when you're talking, I'll keep my mouth shut and listen to everything you have to say. Okay.
Oh, yes.
So the person hired lawyers out in California. The person paid the bond out in California. They sent the information back here and that person was released.
Okay.
We cannot do anything as it relates to that bond out there. Okay. Even if I were to set you a bond here today, you still have the charge pending out there and you would have to satisfy that bond. So if you waive your right to a extradition hearing, that starts the clock running today. It's your right whether you want to waive it or not. If you decide that you want to have the hearing sometime within the next 90 days, as I indicated before, you'll have the hearing. And if the judge determines that you are the person named and the charge is valid, that 30 to 60-day period that I referenced earlier begins to run after that hearing. So the effect of waiving a hearing is you speed up the process. However, you're going to have to deal with this out in California. So you need to hire lawyers out there. Have I sufficiently explained this to you? Do you have any questions?
Yes, you have. I have some questions, Your Honor.
Okay.
So if I get my wife in California to pay the bond in California, they could send the paperwork here and then I can be released from here, right?
Yes.
Okay. And then if I want a hearing, there's no bond. I just have to stay here until the hearing. Is that how it works?
Yes.
Okay.
Yes.
Okay. I have the paper here to sign the waiver of extradition, which speeds up the process.
Yes.
But while this is happening, can my lawyer still get the bond taken care of and I still be released?
You said, can your wife do what?
If I sign this waiver of extradition, right? Can my lawyer in California, still take care of the bond over there and then
Yes. Yes.
so I can be released faster here? Because I have a job that a lot of people depend on me, you know. I really want to attend to the case in California, honestly, because I believe I'm not the person. I've never been arrested before for anything.
Okay.
Okay, so this is definitely confused. Well, I wouldn't really say, but I know it's definitely not me because I never did anything wrong. I can recall, but it is a charge I have to address.
Yes, sir.
Yeah. Also, I just want to plead with you if they can make the accommodation here a little bit better for us because where I'm staying is like we're laying on the floor here. It's really inhumane, and I don't know if I can stay somewhere a little bit more comfortable or private so that I can wait for this process. Because it seems like it's going to take a minute to resolve.
I do not have control over the jail.
Okay. So I should go ahead and sign this paper. Then I contact my lawyer. This warrant number here is the reference to the warrant, right? On the case. The warrant number 2021 W21468. That's written on the warrant that I have here. This paper.
And it's kind of hard for me to understand you with the there's like an echo, a little bit of an echo.
Yes, sir, I have my mask on. So I'm saying the reference number to the warrant is the correct reference, like this number. Is it also going to be the same number in California?
No, the warrant number, you have something to write with?
Yes.
The warrant number in California is W805361962.
I have WA0536.
The letter W, but the number 8.
Oh, 8. Okay.
05361962.
Okay. All right. Thank you so much.
Okay.
Also, how can I make a phone call to my lawyer? Because if I had called him, he would have been, is there any way I can be given permission to make a call to my lawyer?
After you leave this proceeding, at some point in time, you will be able to use the phone today. Again, sheriff's office doesn't work for me, so they have to follow their internal policies. But my understanding is that if you have not used the phone yet, you will have the opportunity to use it once you leave this proceeding.
Thank you so much, Your Honor.
You're welcome. And once you sign that, they'll send it over to me and I'll sign it. And the process will begin to run today. But you should let your lawyers know, at least from my understanding of what happened last week, the state of California, because of the COVID related issues, that they're willing to work with people. And so if you go through that route, you'll be fine.
All right. I really appreciate it. Thank you so much, Your Honor.
Okay.
Your
All
Honor,
right. That completes the calendar.
all right.
I just signed this and gave it to you. Yes,
All 7 copies, all 7 copies.
Okay. And Marie, Miss Body, her violation of Georgia Controlled Substance Act is a felony offense. It's not a misdemeanor.
Thank you, sir.
You're welcome.
Have a good
All right.
day.
Thank you. Have a good day.